So our law enforcement panel is going to go up until 2 o'clock, and then we're going to take another short break. And I would like to go ahead and introduce you guys to Joe McCrae, who's come in from out of town to help moderate this particular panel. Great guy, and he's going to introduce us to our panelists. Thank you.
Let's just real quick check. Oh, would you mind if I use that? Oh, looks like I'm on. All right. Well, welcome everybody. I'm glad everyone's here. We're hoping that this law enforcement panel is a good panel where we can talk about the privacy concerns associated with business and how business and local law enforcement can work together. So we've got a great bunch of people here. I'm going to start on my right. Looks like it's Mark Bayart. Mark, if you could just raise your hand, stand up a little bit. So Mark is the Assistant Head Deputy, High-Tech Crime Division of LA County, for the LA County District Attorney's Office. Okay, and then we've got Jack Furet, Special Agent, Critical Infrastructure Systems Protection for the Secret Service. We've got Hani Fakuri. He's our attorney for Electronic Freedom Foundation, EFF. And then we've got Jason Smolenoff, VP of Business Intelligence and Investigative Practices at Stross Friedberg, and he's an ex-FBI agent as well. So we've got a very esteemed panel of people with a lot of great credibility in the industry. If we could just check and everybody make sure your mics are on. Okay, looking great, looking great. Okay, so the way this is gonna work is I'm gonna start posing each of the panelists some questions, and we're gonna open them up with some kind of softball questions, and then we'll kind of pick it up a little bit. And then we'll carry a microphone around the room and let each of you ask questions as well. When you ask a question, I'll try to direct it to the appropriate person. So for example, maybe if you ask a question on credit card fraud or something like that, I might try to direct it toward our Secret Service agent, but that doesn't mean that one of the other attendees might not chime in. You know, maybe someone from local law enforcement says, well, hey, in such and such situation, we need to be conscious of this as well. So without any further ado, let's get started. So this one, any one of you can answer. Any one of you can answer, just raise your hand, say I'd like to take that one. Generic question, I have a breach. I'm a business owner, I have a breach. Who can help me? Should I call the FBI? Should I call the Secret Service? Should I call local law enforcement? I have a breach. What is the first person I should be looking to call if I'm gonna call a law enforcement type person? Can anyone chime in on that as the first person?
Sure. If you want, I could take that one.
Please, please.
I think when you first get notified of a breach, one of the most important things is to understand, or at least to try to identify what was taken, how long the attacker might have been in your network, and get some basic facts identifying what the attacker might have taken, who the attacker could be, because that type of information will determine which law enforcement agency will come in and be responsible for handling certain investigations. In my time at the FBI, we would handle matters, criminal matters and state-sponsored matters, which would be equivalent to like advanced persistent threat type of issues or intelligence gathering intrusions in which intellectual property was stolen. The FBI is part of the Electronic Crimes Task Force, which works closely with the Secret Service, the DA, and the Sheriff's Department here in Los Angeles. So, identifying what was taken first is really critical. And I think that the next step is, and when I was at the FBI, all you would ever really think about as an investigator is going in and getting evidence, trying to give the company some tips on what to do before you leave. And then that might be the extent of it. Being on the other side in private industry now, I think companies need to think about another array or a whole section of issues. For example, if PCI data was stolen, you're going to have to make notifications to the brands. If Social Security numbers were stolen, you might be looking at an FTC inquiry that might come down with PCI data or Social Security information or PII. Depending on where your network resides, in which part of the world, you might be looking at up to 46 different state and local data breach notification laws within the United States, and that's not to mention the international privacy issues with Safe Harbor in Europe and other countries in Asia. So I think getting kind of a good scope or a good big picture of what happened right away is important. Notifying law enforcement is important, and when to notify law enforcement is important. And I also think that you need to get some outside counsel or outside assistance to help you navigate through the disclosure and notification issues.
Can I add a quick follow-on question for that? Are there concerns of the aggregate dollar amount of what was taken that we need to consider? For example, I've heard some entities say, $200,000. Do you want to chime in on that, sir?
Well, it's all relative. If it's to your organization catastrophic, I would send you to the FBI or the United States Secret Service or a task force. If it's minimal to moderate, and it's all relative to scale. If you're a small business, $10,000 can be a lot, especially if it's a client's money that was wired to you. In those type of situations, you'd go to local law enforcement, but something that involves intellectual property, entrepreneurial malware, definitely belongs with the feds because it could be international in scope. Something where wiring instructions have gone wrong or you're dealing with a low-level hack, someone that you think is a script kiddie or something like that, that's when you come to the LA County law enforcement because we can deal with that. We can deal with something well within our confines or our state. And that's a difficult decision to make when you're dealing with a breach in the beginning. But once you look at what's been deleted or what's been taken, you'll have some idea where to go. If you come to us, the DA's office or local law enforcement, and we find out that that $100,000 breach is actually a $10 million breach, we call the Secret Service because we're partnered with them in a task force.
Okay,
And if I
excellent.
may add on, one of the things that we offer through our task force, and it's been spoken about a little bit here by my colleagues, our task force here in Los Angeles, we have not only Secret Service, FBI, LA County Sheriffs, but we have Los Angeles Police Department and partners, number of local law enforcement agencies, Beverly Hills, Santa Monica, Pasadena, so that if you contact our task force, as my colleague indicated, we also have the district attorney's office, both their investigations and their prosecutorial capabilities, as well as U.S. Attorney's Office for their prosecutorial capabilities. What we want to do is be able to go ahead and be a platform that facilitates you as the victim contacting us. So if something comes into us, and as my colleague indicated, we look at it and say, well, hey, if this may be a state matter, we won't go ahead and say contact so-and-so. On our task force, we all physically sit together. So we have representatives, LAPD, LA Sheriffs, Beverly Hills, Santa Monica, all these other task force colleagues, not only here in Los Angeles, but we have task forces across the United States and overseas. So what we can do is we can go ahead and facilitate that communication for you to one of our local partners, to another state partner outside of the California, or even overseas, as Jason had indicated, if there are other issues. So we're a resource that can go ahead and provide as much as we can for aid and resources when you have that, to take that burden off you as well.
Okay, so just for the audience, I'm going to do one more question and then I'm going to start to open it up for audience questions. I just wanted to ask one more thing. Let's say I'm a business and I'm a fairly decent sized business, but I don't have in-house counsel. So now I'm concerned, well, I'm going to go to local law enforcement, but I really don't have necessarily a PR department or an in-house law firm, in-house counsel. What do I need to be thinking about in terms of media management for the breach and my reporting for compliance reasons? Will local law enforcement be able to help me with that, or am I going to need to seek some external entity to help? Can anybody, just whoever's willing to chime in on that one?
Sure. Go ahead, Jason.
I mean, my first recommendation is that you get outside counsel to help you navigate some of these decisions, because for law enforcement has certain needs and certain requirements. They want to gather evidence and put a case together to make an investigation. Many companies I encounter want to assist in that process, and they assist and cooperate freely. But the company itself has other concerns, I think, when it comes down to regulatory or legal notification requirements. For example, if just working with a small company right now who up in the Bay Area, they've been growing very quickly. They very successful, made probably $10 to $20 million a year in business, and they just had suffered a data breach by what looks like to be an organized crime group. Lots of information, credit card information went out the door, and so they liaised with law enforcement to make a notification so that law enforcement would be able to assist with tracking down who might have done this. But at the same time, this company needs to start to navigate what it discloses, how it gets disclosed, where they need to make these notifications in what states, and what actually gets reported, because they're trying to file an insurance claim to pay for the consulting, the investigative fees, the legal fees, the PR fees. And so what you say, how you say it, and when you say it is very important. And if you don't have legal guidance in-house, even if you do, if that's not your specialty, I would highly recommend getting outside counsel to assist. And I would also have the outside counsel work very closely with law enforcement to see when and where and how you disclose this information. Some data breach laws allow for a law enforcement stay on making these notifications pending an active investigation.
Jason's exactly right. For us, what we want to do as investigators, and also I work also in the computer forensics realm of it as well, we want to make sure we preserve the evidence, try to get you as whole as possible, as quickly as possible. But if there are issues that come up, is you have state notification issues. If there's information, your credit card information, other personal information that you have to go ahead and make notifications on, what we will have the benefit of with our paradigm is when we have district attorneys, not just general district attorneys, but specifically trained in electronic crimes laws, electronic crime awareness, through his office, that were actually with us, as well as U.S. attorneys who work out of the cyber unit, so that we can immediately place, if the CISO or someone has questions of that nature, say, hey, who do we need to talk to? We would say, well, as you go ahead and address those legal concerns, let's go ahead, we already have them assigned to our unit, let's put you directly in contact with the prosecutorial authorities, both federal or state, depending upon where it is, and then they can begin to go ahead and directly interface with you to go ahead and resolve those, or at least address those issues.
Good, good, good. Okay, guys, so we're going to start opening up for questions from the group. My next question is going to be regarding forensic readiness. So if you don't mind, I'd just like to kind of see a show of hands. How many of you have a concern for what types of data that you're going to need to be able to present to law enforcement if in the event of a breach? Just real quick show of hands. I have a concern for that. Okay, so it looks like a couple of people. So my question is, what types of records should I keep if I'm concerned about forensic readiness? As an example, voicemail, email, proprietary documents to my business. As a business owner, as an executive in a business, I'm sure it's probably important to have some of this stuff, but I'm really kind of hoping Hanny could kind of jump in here, because I'm guessing that there may be some concerns with either my business intellectual property, my employees' privacy, or potentially my customers' privacy. Hanny, would you mind giving us a little guidance in this world?
Sure, absolutely. For us, we totally get and understand that companies have to keep hold of data for certain periods of time. Obviously, there's some data that has to be held for regulatory purposes. That's fine. But our biggest concern and our biggest fear is when companies take more data than they need to take from customers and store that data longer than they need to store for. And our biggest concern is that you enter into potential privacy problems, because you're obviously, we're sitting here talking about breach, and there's obviously the concern that that data gets in the hand of a malicious hacker or someone who's going to do harm with that data. But at the same time, there's also the, as this panel kind of indicates, there's a very strong connection between that data being turned over to law enforcement as well. And for us at the EFF, one of the things we've always been concerned about is how much access to that type of data does law enforcement get. Obviously, how much access to that data is the customer aware that they're actually turning over to the company, who in turn is going to turn it over to law enforcement potentially if there's a breach, and perhaps if there isn't a breach. And so, we've always told companies, and we deal primarily with small companies and startup companies and mobile app developers. We've always told them to be very careful in the types of data they take, how long they store that data, and for what purposes they use that data. And I think that can apply to a wide variety of companies as well, to really think critically about how much information about their customers they're keeping. Because when a breach does happen and they have to turn over a vault, if they've got 20 years worth of email correspondence or voicemail correspondence, obviously that's going to help law enforcement do their job. I don't doubt that. But at the same time, that presents, as you kind of indicated, some serious privacy concerns about what is actually necessary to collect and what is actually necessary for law enforcement to do their job.
Can I add on to that? What I'm starting to see is marketing efforts changing now. So for example, the advent of inbound marketing and how that is changing. Now there's a huge influx of people, collecting way more data from their customers than we previously did, just as, through webinars and all these different things that we're trying to do to interact with our potential customer. Now we're collecting a whole lot more data, and then as they go through that evolutionary cycle, we're continually collecting more and more data. Is that something that we should be concerned about as well?
Absolutely, and again, I think the big concern is what is the customer's expectation of what type of data is going to be taken. If you're, as a company, send a survey to your customer and say, we're using this survey for marketing purposes and we want to better cater our products to what your needs are, and a customer willingly fills out that information, well, we're going to have less of a complaint about it. But the real problem is companies that are taking data without being clear to their customers about what they're using the data for, how much data they're collecting, how long they're keeping it for, and then the customer gets surprised when they realize that all this information about them has been turned over to the company and potentially in turn turned over to law enforcement. That's where the real problem comes. And so it's important that if a company is going to engage in collecting a large amount of data, that they're upfront with their customers about what they're doing with that data, and that they're really kind of narrowing and focusing on collecting the data that is necessary to provide the service at an effective and an efficient way.
Okay. All right, so we're going to start opening it up. So I'll be carrying around a microphone. I might have one other person carrying around a microphone as well. What we're going to look for right now is we want to stick on this forensic readiness. For people who have questions on the subject of forensic readiness and what data they should and should not collect, specifically from their customers, or what data they should and should not store. As an example, I've got a client who a few years ago actually had to terminate a CEO. So the board of directors, decided that they were getting rid of this particular CEO. It's a multi-billion-dollar corporation. They had to get rid of their CEO because there was some scandal associated with that. And then when law enforcement came in, they wanted data going back something like 7-8 years. So since then, that organization has just made blanket policies of we won't delete anything. They bought this massive storage solution, and they're just, knee-jerk reaction to, hey, we'll keep anything. I don't necessarily know that that's the right thing to do or the wrong thing to do, but do any of you have any questions of what's the good guidance if we're going to write policy? Does anyone have any of those types of questions? We've got one back here. Okay, let me make sure your mic is on.
And as you're walking back there, if I could just add one thing real quick, and it's not just customer data, but even employee data. How long is a company going to keep a record of a company's, are they going to keep the employees' emails forever? Are they going to have access to the voicemails on their private machine? These raise kind of tricky issues that, should also be thinking about as well.
Well, I think there's two issues that come up. I've had opportunities to write policy concerning retention of data. And the first, I think, is a little bit easier. That is, do I have records online that don't earn me profit? Why, in my right mind, would I have them? on my tapes. And so that would give me a profit motive to get rid of them. But the one, I think, sort of the two cases that showed up as most trouble for writing policy had to do with how long do my legal counsel require that I keep tapes. Lawyers are amazing in their ability to retain data on the contingency that they may be sued one day. And so if I gave them data for an event, 2 years worth of data, 7 years later they can't sign off on getting rid of it. So how do I motivate legal staff to purge records? I guess the other question that comes up very quickly is, well, I think I'm going to stick with the first one.
Okay. All right. So we'll leave this up to anyone on the panel to pick on. We've got an internal policy to hold data for 2 years. In-house counsel is very reluctant to release this data for destruction, even after it's been 5 years, 7 years. Am I summarizing the question correctly, sir? Okay. He's curious, should he be working to motivate in-house counsel, hey, it's okay, we can delete this, or your take on it, sir?
Well, I'm not a civil attorney, nor do I play one. But I'll give you some unsolicited advice on this topic. If you're a CEO of a company and you find out that one of your employees through HR has a sexual harassment suit, I would want every single email that was ever sent between the plaintiff and the defendant, even if it goes back 10 years. And I'm a civil attorney, and that's my hat here. And I can understand that that's a problem for the IT department, but that's how lawyers think. We want as much evidence that we can get. And we'll ask you to go back 400 years if we can. That's how lawyers think. And that's the balance between IT, between the XO and the C-suite people, and the legal department. And that's the balance. And you have to come up with a number that works. Is it 8 years? Is it 10 years? Is it when both of the employees are no longer with the company, can we get rid of those emails? And something else to think about. Enron was built on their email database. The government had every single email that Enron ever had in their 9 years before they collapsed. And that was one of the most successfully prosecuted cases in the history of the United States against a corporation, based on the email database.
Hanny, are there any concerns with that?
Oh yeah, absolutely. There's a real serious risk to employee privacy, customer privacy by keeping those records. I agree with you that if I was a civil litigator, I would absolutely want every shred of evidence I have. But again, that presents that kind of balance issue. On the one hand is, it's going to be great for litigation if and ever when we need it. And on the other hand is the real privacy concern that it's open for misuse by who knows who, rogue employees, hackers, whoever is curious to see what other people are, emailing each other. And so I agree that there has to be a balance. Is there a hard and fast number that I can just throw out there? No. I think every company has to kind of assess its own needs, but I think that as a company is writing a policy and thinking about its needs, it should try and keep some of those things in mind. And as well, I think, again, importantly, is to be very clear and upfront with the employees what the policy is so that they can adjust their expectations and know to keep the harassment emails through their personal email accounts or do it on their personal time.
Okay. Do we have we have another question on this subject? The mic looks like it's on.
I've also heard the opposite in some cases where you want to have a policy and make sure you stick to it and have the older data gone for protection of the corporation, that sometimes that old data can be negative on you.
I completely agree with that statement. And it depends on, I think we need to kind of define what kind of data is being retained. So emails, or if there's a litigation hold, you need to retain that information. The case that I brought up a little bit earlier about the company who had a data breach, they're now looking at significant fines for having millions of credit cards walk out the door. upon analysis of looking at those credit cards, over 2/3 of the credit card numbers and information that went with that was all expired data, but they're still on the hook for the fines for those credit cards going out the door, making the notifications, having the brands fine them for having that information. So I think it's important to come up with some type of policy that purges protected information at a regular basis that's still within the confines of the law, but also protects the company. There's no reason to save millions of credit cards that are expired, that really have no legitimate business purpose, but if it does get hacked, that company is on the hook for making good on those.
That probably should help your previous question where you're about business purpose. And then, there you are, sir. And is it satisfactorily answering your question? All right, good. Okay, so this kind of leads me to think about something. Oh, I missed someone? Can I see a hand? Okay. Mic is on, here you are.
We have a very distinguished panel. Thank you guys very much. My question is, in today's cybercrime world, what do you see as the trends pertaining to organized crime involvement in this new growth industry?
I'll go ahead and take that. From our perspective, both at a federal and local level, you have to, first of all, going back to my law school days, define what you mean by organized. If you're talking organized and you're thinking about the Sopranos or, the Gambino crime family, you do have, of course, as anything, it's organized crime. There's always that element there to try to go ahead and do something illegal to make money. But organized also, if you open that definitional construction to include a very defined working group, if you will, that has research and development capabilities, penetration capabilities, a command and control structure for a criminal purpose. If you define it that way, yes, okay? I think a lot of us, 15 years ago, we would think about, oh, hey, war games, that lone kid out there who's going to hack in accidentally. That still happens. But from an organized crime perspective, you have people who are all around the world. I won't get into a lot of that granularity, but both foreign and domestic, who are targeting systems, who are targeting companies. They're very well schooled in what they're doing. They know exactly if they can't figure out what the breach is, they'll reverse engineer it. So you do have, as I said, a very directed group of individuals that are looking at across the ISACs, across the spectrums, financial, public and private, who are going toward that. So I think from that perspective, I would say yes, there is that mix of organizational or organized crime component to it, if you use that definitional basis to go from. Does that answer your question? Yes, ma'am.
Okay, great. Wonderful subject. I actually want to hit that subject a little bit, probably in about
Jason,
5 more
you wanna
minutes.
key
A very good subject. Someone had
I'd
a...
ask,
Do you mind if I just jump in on that? I like to think of it too as looking at it as in attacker categories and what kind of attackers are using what kind of tools. So certain attacker groups tend to use certain tactics, techniques, and procedures. That's what law enforcement term, or a term of art in military, for TTPs, and the behavioral aspects of how they attack a network. So I like to look at it in terms of 4 groups. One is the state-sponsored hacker, right, or organization, in which those are individuals who have the full backing of a government. They might not be directly employed by a government, but they could be a proxy of a government. And they use certain tactics, and they have certain goals of not financial theft, but more intelligence gathering theft. There's other groups who are, we'll call them cyber criminals, and those groups use certain types of, tend to be more financially motivated. So, you hear about them from Eastern Europe or from countries in Africa. I would say you have a third category, which are the hacktivists, or people who, like the Anonymous, the LulzSec, who are not so much looking for financial gain, but they're looking to make a point, and they're very loud about it. They tell you in advance that they're coming to attack your network, and they want something from it. Then you have the fourth group, which is somewhat the script kiddies. I mean, they tend to be going away, but I think they're still going pretty strong. There's still quite a few cases out there with those rogue cyber attackers. So I think when you put it into categories of attacker, the behavioral aspects of how they attack someone, it helps to start categorizing it down so that you can understand what type of attack is happening if something's going to happen. Or on the proactive side, if you feel like you have a risk to, say a couple of years ago with the SOPA legislation, there were a lot of entertainment firms who were being targeted by Anonymous or LulzSec. So knowing that they were going to sign this legislation, a lot of these firms took proactive measures to prevent DDoS attacks. So knowing some classifications and how they operate, if you feel that though they're threats to your organization, that helps to prioritize how you should set up your defenses or your defense in depth.
Okay. You have a question? Just give me 1 second. Okay, this subject I want to come back to. I want to still go back to data, if you don't mind my asking. My question is, are there cases where, as a business, we would prefer not to use encryption? You know, we always hear all these encrypt my data in transit, encrypt my data at rest, you know, all these things. Are there cases where I want to explicitly be very conscious and say, you know, in this situation, I might not want to encrypt this for whatever reason? Or are there cases where I may want to encrypt it, but I have to be very, very conscious of my ability to get that data back? Example, an employee leaving or something like that. Can any of you speak to that?
Well, my feeling is you encrypt everything, from flash drives to hard drives to everything up and down. One reason is HIPAA. If it's encrypted, you do not have to make a notification of a breach. That's how strong the law is and feels about encryption. One of the problems is when you have that employee that leaves. We recently had a case like that in the DA's office where an employee took their own company information that they were allowed to have, and per company policy, they were allowed to put it on their own laptop, which they encrypted. That employee walked, and the company said, we want the laptop with our information. And they called us and said the employee won't hand it over, and we said no crime's been committed. It's their laptop. Your information may be on it, but there's no mechanism in criminal law to force that person to export the information. If it's encrypted according to the procedures of the company, you may be able to still block someone else from receiving that data. And that's a situation where the company has to obtain a civil attorney. But our feeling is you should encrypt everything.
Excellent, excellent. You have a question, sir?
Hi guys, this is Dan.
Hi, Dan.
How you doing? Long time listener. Anyway, I had a question for you guys. You know, this whole encryption thing just kind of like just light bulb goes off. So you're telling me then if I have all my data encrypted and lo and behold I have some sort of breach, then that is not necessarily something that has to be reported.
Under HIPAA.
Under HIPAA, but not necessarily the other different trivial little things that are out there with regards to, like, I don't know, PCI.
There you would have to get a civil attorney.
Yep, okay.
I can tell you black letter law, interpretations, I'm straying out of my lane. Yeah.
No, I understand you're out of your
Yeah,
lane.
yeah.
I just, you know, that was just a little light bulb. And it's like,
Yeah.
wait a minute, you know.
I can just give you one quick example of why you should probably encrypt your data. There was we just recently did a case for a bank. The bank was backing up their file servers to tapes, and the bank actually lost tapes containing terabytes worth of data, okay? So they couldn't actually tell if the tapes had been lost, if the tapes had been overwritten, or what had actually happened to them. So as a result of that, the bank needed to go ahead and try to identify what was actually on those tapes, what needed to have disclosures associated with them, and it cost quite a bit of money. Now, if that data was encrypted and it wasn't able to be found, they might not have had to go ahead and spend all that money to figure out what was actually on that tape and figure out what and how they should disclose. It costs in the low millions of dollars. So, a simple thing of encrypting your backup tapes or encrypting anything that's going to have potentially sensitive data on it, that's going to be at rest and not being used, is, I think, from a business perspective, probably a good practice to have.
I was just going to say, just any proactive measure, just from a law enforcement perspective, any proactive measure that secures your company, your employees, your company, and its status, that's the best measure to take. And whether it be encryption or any other proactive steps, try to go ahead and secure that data. That's the most important thing at the end of the day.
And of course, for us, it's the best practice for your customers too. It's going to keep their data secure and minimize the risks of breach.
One of the questions I get is who watches the watchers, quote unquote. We've got our IT admins, we've got our people who have access to all the goodies in our company, and if there's a situation, so I might mess up some of the details, but the gist of this was 2 years ago, maybe 3 years ago now, in Virginia, there was an employee who worked for some state entity, and he worked there as an IT person. He was disgruntled because he was being laid off. He actually encrypted all of the organization's data and then threatened them, for money, and so it kind of sparked this whole debate of who watches the watchers, if we will. We've got these people that are admins in our company. They have the keys to the kingdom. So even if we have encryption, they have the keys to decrypt it. Even if we have whatever protection mechanisms, they're the ones who control those protection mechanisms. I really didn't see a lot tangible things come out of that debate in terms of watching the watchers. Do any of you guys have any opinions on that?
Well, I know, picking up what Jason had talked about, the 4 categories, and I would say there's also what we would call in law enforcement the 5th category, and that is the insider threat. For much of, in many of the years I've done cyber, there's always that tendency to think of cybersecurity in terms of the shell, the fort. Very hard perimeter, if you're going to use military idea, very hard, secure perimeter, nothing's going to penetrate it. But at the same time, you have to think, okay, I'm hard on the outside of my fort, but what happens, what can I send out? What can be sent out? Can data be sent out? Things of that nature. So what we would do in law enforcement, and we try to go ahead and working in this public-private partnership, is to go ahead and to give that type of education of, hey, listen, as you said, trying to go ahead and realize there is that insider. You do have individuals, maybe employees or someone who may be a third-party vendor who has possession of your information. Go ahead and monitor your stuff. Do audits, do checks, do penetration tests, do things of this nature. Also, check what your employees are doing, whatever your policy is. I mean, we don't, from law enforcement perspective, formulate policy for the private sector, but we really do, and I think my colleagues from the prosecutorial side as well would agree, of anything that you can go ahead and do that helps your company in terms of its strength, both internal and external. You have to consider both of those when you're formulating some type of cybersecurity plan.
Mm-hmm. Excellent. Okay. Well, we got a bunch of hands here. Okay, we've got a really active person here. Okay.
Thank you very much. Hi, guys. I have a concern to share. I know there is a lot of intrusions, but I found that there is an intrusion probably more than others. This is an intrusion for the whole network. There is a spy from China. He invaded the whole system by advanced system. He has his advanced HTTP system. He stole a Microsoft web flash detections and wiped out all Microsoft resources. He stolen HTTP system drivers. He stolen remote access. He upgraded them. He's a remote king, remote queen. Remote access to any computers, and I've been controlled for over 3 years. I have all the photos. He hid his text inside Google, inside Yahoo. The normal look as Google and Yahoo, but inside property is not. So please take a look. I'll give every one of you, take a look how serious this problem is. No matter how wonderful our security products, you do not know the second HTTP system exists, it will not reach him. So the bank has been in and out, and he can get in any bank, my account anytime and post anything. Okay. So I just bring this concern. Should we keep this HTTP system advanced, or we take him down? Thank you very much.
Oh, okay. So if I'm understanding correctly, you had a breach, your account was compromised?
No, not only my account, it's the whole.
Several people?
Not several people. Connect up. White House have a cybersecurity, have a cyber address is his address. FBI have cyber address is his address. And Google, Yahoo, the same, everybody.
Okay.
Thank you. We'll definitely take this.
Thanks.
All right, thank you. Okay, so next question I wanted to kind of bring up is the Patriot Act. So we've seen things in the news about people talking about the Patriot Act, and my question was, do we have any people with business concerns for the Patriot Act? So maybe you're going to have cellular communications, voicemails that are going to be logged. Do you have anything like that? Because it's been extended recently.
Yeah, this is very aggressive because I had some. This is very timely because if I'm not mistaken, there's current legislation where the federal investigative agencies want to have a backdoor in possibly not just infrastructure entities, but also possibly corporate entities as well, to aid investigation. So that's quite a matter of debate. But what I wanted to ask you in a broader manner is there any work that any of the federal agencies are doing, Secret Service, FBI, what have you, are they working with any standards organizations and industry to try to come up with an architecture recommendation about having standards of a honeypot, standards of having behavioral analysis software in place, standards of what audit logs really should be available for possibly X period of time, logging forensic trail information about incoming traffic and what might be done for system exploits. So you have so much expertise when it comes to investigation and the things that you forensically need. But it's bedlam out there from the standpoint of different industries, different systems, different platforms. Everyone is doing their own thing, and it's got to drive you crazy. So that was kind of two parts of questions.
Wow, that really kind of leads me to think of there's a ton of outreach being done right now by our Secret Service, being done by our FBI, centering around some of that, educating local businesses and things of that. I'm going to carry the mic around for some other questions. Can any of you speak to that while I carry the mic around?
I'll go ahead and address it. From the Patriot Act, to begin with, Secret Service received, as part of the Patriot Act, the establishment of our electronic crime task force paradigm. And what it sought to do at its core is exactly address, to an extent, in terms of creating that across the spectrum, operational spectrum dialogue between public and private partnerships. When we talk about a task force, not only do we have all the law enforcement components, but our task force model is unique in that we actually have members of the task force who are private sector. And what we try to do is work with them, and not only in terms of information sharing, but also through federal partnerships with both academia, different types of corporations, to come up with exactly what you're talking about, that exchange of dialogue, trying to go ahead and figure out how do we all make ourselves more secure, because you can strengthen one part of the operational spectrum, one particular ISAC, but everybody's interdependent. So what we have to do is try to come up, as you said, with strengthening all of the operations as we can, or all the entities as we can. It is an ongoing process and procedure, but I think what we try to do is, with this paradigm that we have in conjunction with other programs that are out there trying to go ahead and address just exactly what you said through U.S. CERT, through different types of partnerships. I know a lot of the big corporations are involved in things like that to try to go ahead and do it. But again, it's hard as well because what works for one company in terms of creating a security and say, hey, this is the ideal security model, okay, it works. Well, then you take that, and that's for a company of 150,000 employees, it works globally, and then you try to shrink that and put it into a model that's a small business, 120 employees, that works in a county. That smaller entity may say, hey, listen, we don't have the resource, we don't have the concerns, we don't have this, we're just looking at this server. How does that model? So to try to come up with a model that covers all of the operational spectrum, I don't think you'll ever, you'll never have the perfect solution. But what we are trying to do is hit every part of the spectrum so that we can create a unified response. So I think that's what we're moving toward.
And if I could real quickly talk about the backdoor for a second, and just so I think everyone's clear about what's going on. In 1994, Congress passed a piece of legislation called CALEA, which is the Communications Assistance for Law Enforcement Act. And what CALEA did was it required essentially phone companies to create a backdoor into their system to allow law enforcement to be able to access real-time telephone communications. Basically, it allowed to require phone providers to ensure that their phone systems were capable of being wiretapped if the government got the appropriate legal authorization to get a wiretap. But when that legislation was passed in 1994, it was only specifically aimed towards basically telcos. It didn't apply to internet architecture as we know it today. So while AT&T's landlines and their cell phone service have to have this kind of backdoor capability built in, Google is not required by law to have the same type of backdoor in for Gmail or chat and any other company for that matter. And now the debate that's been more prominent in the last year has been whether law enforcement is going to basically what they've called, are they going to go dark, in other words? And what they have told both, they have been saying for many years privately, but in this year have been much more outspoken about, the FBI's general counsel especially, has indicated that there's a fear that unless they get this same kind of backdoor capability into online communications, that they're going to have a harder time investigating crime. And so there's this kind of ongoing debate over whether it's a good idea to do this sort of thing, what type of, you mentioned standards, would there be some sort of standards, how would that work in practice, whether that is going to make us more secure, or is it going to make us less secure? Because when you build a backdoor, yes, we want the FBI to go into the backdoor, but that's not going to stop other people from going into the backdoor who we don't like sniffing around our online communications. And that's, no legislation has been formally introduced yet to do that, but it's been something that's been whispered about and now much more prominently featured. And again, I think you guys can all bet, EFF, we're obviously against those types of backdoors. We think, again, it's a security risk. We think it stifles innovation, and it harms privacy because it not only allows nefarious people in, but it also gives the government easier access into information and communications data that we worry that there's, they may not, that there's a risk of abuse, that there's a risk of overuse, of trying to get it more frequently than it needs to be obtained.
Okay, I'm just going to throw in one thing to answer your question. I've worked quite a bit with both the FBI and the Secret Service. There are a ton of outreach programs now, specifically through the InfraGard. Most major city Secret Service offices have some sort of local community outreach. I know one that I'm heavily involved with this is Charlotte. Since there's so many bank headquarters in Charlotte, the Secret Service has these once-a-month meetings where they get all the business owners together and they start to talk to them about reporting cybercrime and all the different types of things. And they even will give information about cases that they've prosecuted. Also, in very recent, we've had the FBI start to bring large ISPs together and work with these ISPs specifically on distributed denial of service attacks. So we're starting to see that as well. So I believe that both the FBI and the Secret Service, I don't know that I would go so far as saying that they're making standards, but they're definitely opening up those doors of communication more so than in previous years. And I don't know if I'm overspeaking, but.
And that's exactly, and just, for point of clarification with my comments, it's, well, we're not making standards, anything like that, but we are doing exactly, as Mr. Cray indicated, we're trying to go ahead and through our ECTFs have this partnership and be able to go ahead, and if you are here in the Los Angeles area and you needed some information, please feel free to come up and I'll be more than happy to point you to our agent in charge of our Electronic Crime Task Force and be able to go ahead and enter in some dialogue with him. But as I said, nothing on standards or anything of that nature, but trying to foster that relationship across the different public and private spectrums.
Okay, I'm going to let these next two questions go back to the Patriot Act, if that's okay. Go ahead, sir.
Yes. So I work with a company that has offices around the world. And what I've noticed in the last 3 to 6 months is an increasing concern in our global customer base about the Patriot Act. Yeah, and our customers, especially in the UK and Australia, are concerned about what part of their information may be made available to the US government. And as a result of that, they're asking for our data processing systems to be situated in their geos. My question to you is, what messaging or resources that you can comment on that can help us assuage or reduce their concerns about the Patriot Act?
Well, you want me to?
Yeah,
okay.
Go ahead.
So,
Good question.
in order for the U.S. government to obtain information from another foreign government or a foreign jurisdiction, there's two ways to do it from a criminal standpoint. One is through the Mutual Legal Assistance Treaty, and that would be for a criminal matter. And the other one is through a letter rogatory, which is more of an informal request between the two countries that may or may not be a party to the Mutual Legal Assistance Treaty or MLAT treaty. So I think, in order to gather that information or even request that information, there has to be a crime that has been committed, and they have to show probable cause that there's probable cause that the crime was committed and that the evidence that is in that foreign jurisdiction will actually assist them in prosecuting the crime. So it's a fairly high standard to meet, and especially to have countries interact with each other in a way where you actually can transmit that information. So I would say that while it's not impossible, I mean, it's the standard or burden is fairly high, and it's a fairly lengthy and cumbersome process to get information from a foreign jurisdiction back into the United States.
Okay. To caveat on that, I've done some work internationally, and there are several European countries that are very, very stringent about their privacy data. For example, Belgium, they're very, very particular. For example, they won't give passport information of European Union people who pass through the country. So I thought his question was really, really good, because he says, hey, what if I'm doing business with someone over there, or if I have an office over there, do I have concerns for the customer data that I'm collecting potentially? And then as well as Patriot Act, anything like that. Hanny, would you mind just kind of throwing in a little nugget on that? I really appreciate your opinion on the subject.
Did you want to add one last thought, and then I'll jump in?
I was just going to say, too, from an investigation standpoint, now that I'm outside of law enforcement, we run into that issue quite a bit. Say, for example, in Europe or in some countries in Asia, they have very strict laws in which data can't pass outside the boundaries of their country.
Sure.
So one of the things that we do to help facilitate some of the investigations is we actually bring teams, keep them in country for the entire investigation, and also bring mobile forensic tools and mobile servers that go into the country to actually do the investigation, where everything stays contained within the country to assist the company with not only performing an investigation, but complying with the host country's laws on privacy. So.
Well, you know, with the, and I know I only have 5 minutes, so we only have 5 minutes left, so I'll be quick. But one of the real worries and concerns with the Patriot Act, and one of the big controversies surrounding the reauthorization of parts of the Patriot Act at the end of last year was basically it had to deal with FISA, which is a Foreign Intelligence Service kind of, it's the Foreign Intelligence Service Act, but it really governs the capability of the United States government in terrorism investigations to basically monitor electronic communications that are occurring between a person in a foreign country. And in those instances, the FISA court, which is very secret, its opinions are secret, no one's, you know, we had to fight, EFF had to fight to figure out who was even on the FISA court, and so there's a lot of secrecy around it. One of the big problems is, and there's been litigation on this, is that there have been abuses of the FISA court process. There's a sealed, secret opinion where, I think an Inspector General report, or even the FISC, which is the Foreign Intelligence Services Court, essentially, found that there were constitutional abuses in the FISA process to get an order to basically intercept phone communication records of foreign nationals. And so there's a real worry that with parts of FISA being reauthorized at the end of the year, this allows the government the ability to perhaps illegally wiretap or listen in on communications that are occurring with people across, you know, overseas, even if they're not necessarily suspected of any criminal wrongdoing in and of themselves. In fact, one of the lawsuits involved lawyers for someone who was suspected of engaging in, you know, terrorist acts abroad, worried that their phone conversations with their clients, which should otherwise be attorney-client privilege and not necessarily subject to interception, were being surreptitiously recorded. And so there's a real concern that any time we give authorization for the government to basically make it easier for them to access communication records, whether it's over the phone, whether it's through CALIA 2, which would create this backdoor into online communications, we run the risk of allowing kind of the government access to a faucet that doesn't easily turn off. And so, you know, what I would say is we have to be very careful about how we, when we do, you know, when legislatures are considering this type of legislation, we have to be very careful about what types of communications and evidence we want and data we want to be given to law enforcement, and what types of standards we want to ensure that our privacy is still being protected. Again, it kind of comes back to the whole point of this whole panel, which is there's a balance to be struck between privacy and security, and we just have to be very careful about how we strike that balance so we don't get security at the complete cost of forever abandoning all of our privacy rights.
Okay.
And just one quick point of clarification. For, I think what we were talking about with Patriot Act and data privacy, the MLAT and letter rogatory is for criminal process. It can be used, I think the FISA information or the FISA process that Hanny's speaking about is really strictly for intelligence gathering missions and intelligence-driven national security investigations. And I can say I've been a part of a few of those on both a criminal Title III wiretap, drafting those, and drafting FISA applications for intercepts. And what I could say is it is a very onerous process. There's over 30 or 40 approval levels that take place. So it's extremely difficult to get the authority to do that type of wiretap, whether it be criminal or national security. So I just wanted to kind of give a little balance to the arguments here.
Okay.
Thank you.
Well, I'd like to thank you, all of you, for being on this panel. We're going to wrap up right now. I think it was really good. I think it was really insightful. I learned a lot. I hope you guys got some good benefit out of it. I'm sorry there were several people who we couldn't get to your questions. These people will be available. I'm sure that you'll be walking around throughout the conference. I encourage you, please come up and meet them, exchange business cards, and ask questions. And again, I thank you for your attendance. I really appreciate it, everyone.